last time on corporate law, we examined corporate restructuring and we commence with the internal option. We examine the various options available for internal corporate restructuring. So today we are going to be looking at external options in corporate restructuring. To start with, what are the reasons? What could be the reason, likely reason for external corporate restructuring? Number one, it could be the need to consolidate in order to maximize market opportunity. In other words, two companies can come together in order to maximize opportunities in the market. Number two, it could be government directive in order to avoid corporate collapse, which it is believed may dent public and international perception of the Nigeria economy. Number three, it could be the need to leverage on the economic of scale in order to reduce production costs and optimize profit. For instance, when you have a company with a waste product serving as a raw material to another company. A practical example would be like the Basita Sugar Company. Some of the waste product from the Basita Sugar Company become useful to the Jeba paper mill. So there may therefore be a discussion between the Basita Sugar Company and Paper Jeba mill to merge in order to reduce cost of production and optimize profit. So these are few of the reasons for external corporate restructuring. Don't forget, we said it could be the need to consolidate in order to get a good grip of the market, or in order to avoid collapse, or in order to leverage on the economic of scale. Second issue in this topic, therefore, will be what are the options in external restructuring? What are the various options open to companies? Just like we examine the various options open under internal or the internal option, we also have the various external options. Let me give you five of them. Number one, merger. Number two, a takeover. Number three, acquisition. Number four, purchase and absorption. And number five, management buy-in. So, having examined the various reasons or justifications for external corporate restructuring, we have also examined the various options of corporate restructuring, external options, merger, takeover, acquisition, purchase and absorption, the management buy-in. Then let's examine these options one by one. So let's start with merger. Merger is defined to mean the amalgamation of the undertaking or any part of the undertaking of two or more companies. I refer you to section 92, sub 4 of the FCCPC. It may result also from acquisition of shares and assets or a corporate combination. A merger typically, therefore, is amalgamation of two or more companies or acquisition of 51% shares in another company. I refer you generally to section 92 to 94 of the FCCPC Act. What are the various economic forms of merger? There are basically three economic forms of merger. A merger could be horizontal, a merger could be vertical, a merger could be a conglomerate. So let's start with conglomerate. When you say economic form of a merger is a conglomerate, you are saying where two companies operating in different markets with unrelated products come together to merge. Then you say that is a conglomerate. In other words, the two companies are not related, whether by way of raw material, they have no connection really. So when they come together to merge, then you could say, oh, this is a conglomerate. Companies operating in different markets. For instance, let's say a company into productions of cement merging with an airline company. You could say, oh, that is conglomerate because they are not in the same industry, they are not in the same sector, they are in different sectorial and economic or industry. Then we have, on the other hand, vertical. A vertical merger is a form of economic merger of companies in the same market. Vertical merger is characterized by the fact that the companies are in the same market but in different level of production. I recall I gave you an example of Basita Sugar Company and Basic and Sugar Company and Jeba Paper Mill, or a typical example you could also relate with is a margin of a sack producing company with a cement manufacturing company. For instance, in Nigeria, we have Bako Super Sack PLC, and then we have Dangote Cement PLC. Don't forget, the Dangote Cement is packaged is package is branded and is packed inside a bag, and this bag it may be produced by the Baco Super Sack PLC. So if there is now a move between the Baco Super Sack PLC and Dangote Cement to collaborate to come together as an entity, then you say that is a vertical merger. A vertical merger is always from the north to the south, and then on the other side of vertical merger we have the horizontal merger. Horizontal merger is a merger between two, is an economic form of merger in the same market but and same level of production. Don't forget, in vertical merger, we said same market, but not the same level of production. In other words, the example I gave you, there is productions of the cement before you come to the level of packaging the cement. So, but in horizontal merger, same market, same level of production, same product, same target customer. For instance, a merger between two banks, if two banks coming together, like when you have Standard Trust Bank PLC coming together with United Bank for Africa that time, that produce what we have the UBA today, that is a horizontal merger. Two companies in the same market, in the same level of production, coming together to form to merge, then you say that is horizontal merger. So don't forget the technical difference between horizontal and vertical. In vertical, on the other hand, we said they are in the same market, but not in the same level of production, not in the same level of production. So let me still give you another example of what could be a vertical merger. Let's say a company is involved in producing stones and laterals, and then there's another company involved in construction. Now, if these two companies come together, they are in the same market, but they are in different level of production. Then you could say, oh, that is a what? A vertical merger. So why vertical merger is not to south by way of description, a horizontal merger is from the west to the east. All right, so let's take a look at the next. The next issue is categories of merger. So far, we have examined what is the meaning, what is corporate structuring external option. We identified the reasons and the justification. What could be the reason for external corporate restructuring? We also look at the various options. What are the options? After we look at the option, we now started one of the options identified is merger. That is what brought us to merger. We have defined what mergers mean. We have also examined the economic form of merger, and now we come to categories of merger. Basically, mergers are classified in terms of the combined monetary value. In other words, the combinations of the turnover and asset of the merging entities. So if there are two companies coming together to merge, the combinations of the turnover and asset of these two entities is what will enable us to determine whether it's a small merger or a large merger. Before the FCCPC Act, we used to have as well the intermediate merger, but now we have the small merger and just the large merger. All right, what are the preliminary steps to merger currently in Nigeria? Okay, we start with there is a need for pre-merger notification, which will be sent to Federal Competitive and Consumer Protection Commission, which is provided for under the Federal Competition and Consumer Protection Commission Act. And then there is the need for MOU and Technical Implementations Agreement, otherwise called TIA, the legal due diligence and draftings of the mergers and acquisition agreement. All right, what is the steps towards approval? How the merging entity, how do they set out in order to secure approval? The set out comments, FCCPC will set out the notification threshold from time to time, but till now they have not been, we are not aware of any notification so far. But the position of law currently is that regardless of the categories of merger, whether you call them small or large, provided the threshold provided they come within the threshold as stipulated by FCCPC, there is the need for a prior notification uh, that will be sent to FCCPC. So therefore, regardless of the categories, a proposed merger within the notification threshold shall not be implemented unless there is prior notifications and approval from FCCPC. I refer you to section 93 sub 1. The merging companies are therefore mandated to take the following step. Number one, to have a pre-merger notification and to make a formal application for approval. And after approval and the completion of the exercise, to bring in post-merger notifications of compliance and make consequential filing with FCCPC, with CAC, and as well with SEC. Okay. All right. So procedure for merger now. We have said that the procedure for merger commences with the notification for FCCPC review, evaluations, and clearance of schemes of document. FCCPC will consider whether the proposed schemes will cause substantial restraint of trade or a monopoly. Because you see, the excess merger must not resort into a restraint of trade and monopoly that will kill off totally competitions in the market. It is preferred that that the market is competitive and everybody coming in to participate. But when merger schemes will result into a monopoly, then the same may not be allowed. And even if it's allowed, as I will show you, another may be made again, that the merger approval be revoked. Okay, there is a need for letter of consent and FCCPC approval in principle. Then application could be made to the Federal High Court for another to convene meeting, a special resolution at the court order meeting approving the merger scheme, the application to FCCPC for approval, which must be accompanied with some document talking about 2 copies of the merger scheme duly signed by the merging company, resolution passed at the separate court order meeting of the company, an extract of the minute of the court order meeting approving the schemes. All right. So these are the items. They're clearance by FIRS because sometimes when companies merge, depending at the stage, at the financial level, at the financial period of the year at which they merge, it could result into loss of payment of taxes and what have you. So there must also be clearance from FIRS, a copy of resultant memo where applicable, then from CAC 7, CAC 7A, CAC 2, CAC 2A, in respect of private companies, and evidence of payment of filing fee and any other form, including FCCPC, notify the court in writing of the approval or otherwise. All right, let's come to post-merger compliance. When the merger have taken place, subsequently, it is expected that the company will file a copy of the court order that sanctioned the scheme, copies of new newspaper publications of the order, statement of the actual cost of the schemes, notifications of completion of merger, and situations with employees, shareholders, and shares of the company. And then there is also what is called post-merger inspection. Post-merger inspection comes, that is, after the merger have been done, FCC has the power to inspect, like I said, to ascertain the level of compliance with the schemes of merger, and to also ensure that the company carry on, and that also ensure that it has not resorted into an healthy monopoly in the market and all that. So it will be done 3 months after approval to do all this. Then it is expected that the new company merge, we coming out of the merging exercise, we register at Corporate Affairs Commission, okay, updated with their updated annual return, original certificate of incorporation of company dissolved in the merger for cancellation, and the evidence of complication of court order in Gazette and national newspaper, the court order. All right. Note that in a merger and acquisition agreement, which is prepared by lawyers involved in the course of the merger and acquisition exercise. There are certain clauses that must be included. So we call them silent clauses in a merger and acquisition agreement. Number one, parties, date, reciter, basic terms of the acquisition, representative and warranty, corporate authority, consent and authorization, financial statement, title to property, litigation, if any, pending involving the magic company. So there must be a details about that. Employee matters, license issue, compensation plan for employee. Okay, are we going to retrench? What will be the outcome? Full and complete disclosure, covenant and undertaking, notifications of default, indemnities and insurance, conduct of seller business prior to closing, and conduct of purchaser business prior to closing. The condition to closing, amendment of the schemes, terminations and effect of termination, issues of dispute resolutions, and maybe there's need for arbitration, extension, applicable law, miscellaneous, and definition. All these are to be included in a merger schemes. All right, before we go to the next corporate restructuring external option, talking about takeover, let's recap a little of what we have said under merger. We define what merger means. A combination of two companies coming together. We also talk about the economic form of merger. We said there are three economic form of merger. That economic form of merger could be horizontal, it could be vertical, it could be conglomerate. And don't forget, we said why vertical and horizontal are on two sides, that is to say, two sides of coin. On the other hand, we said uh, conglomerate is coming together of two companies not even related at all. They are not related. They are not in the same product. They are not in the same market at all. All right. Then we define the two types of merger. We said the merger could be large, it could be small, but the threshold to determine what is a small merger and a large merger is left by the FCCPC Act to the FCC, talking about Federal Competitions and Consumer Protection Commission, to come out. But we now said that by the provisions of law, that whatever is the threshold, whether small, whatever be the form of them, whatever be the type of merger, whether small or large, if it comes within the threshold as to be determined by the FCCPC, then there will be need for prior notifications and approval from FCCPC Act. So we discussed about steps towards merger. What are the things you must do before the merging exercise, and what are the things to do in the course of the merging and post merger exercise? And we discuss about compliance and consequential filings with FCCPC, with SEC, and with Corporate Affairs Commission. We also examine the power of FCCPC to revoke an approval given for two companies to merge if the circumstances or the resultant effect result into an unhealthy monopoly in the market. We said they have the power to do so. Then we examine the various clauses to be included in a merger agreement. Okay? All right, so we go on to takeover now. A takeover, on the other, number two now, takeover is an acquisition of up to 30% or more, but not more than 50% of share of a company. Note that it cannot be made to fewer than 20 shareholders representing 60% of the company membership. And a takeover bid is an invitation to trade deemed dated on the dispatch date and contain matters specifically mentioned um, under the Investment and Security Act, Section 136, and subject to SEC approval. Approval lasts for 3 months. What are the documents to file with a takeover bid? The application letter, your copy of information memorandum, letter of no objection from regulatory body, shareholders and BOD resolution, certificate of incorporation of overall company, members of overall company, and letter appointing financial advisor to the offer. All right. Okay, acquisition on the other hand is taking up less than 30% of shares of another company. So that is the decision between acquisitions and a takeover. Then we have purchase and assumption. Under purchase and assumption is acquisition of asset and undertaking of a moribund company by a going concern and assumption of its liability with a view to turning it around. When you talk about purchase and assumption, it's usually that a company, a moribund company, um, it's like a cherry picking arrangement. It's like the you purchase the company, so you assume the liability, you take the liability while you also see what can be done. But the good thing about the asset of the asset of the company is also acquired by the new company. So, for instance, Trade Bank PLC was purchased in that regard by a UBA PLC. Allstate Trust Bank was taken by EcoBank, and then don't forget that in purchase and assumption, while you undertake, while you acquire the moribund company, you also take the liability of the moribund company. Note that before purchase and assumption is done, there must be a good legal due diligence and the purchase of the asset of the company, because why you must do a good legal due diligence is that when you purchase the asset of the company, you also assume the liabilities of the company. So it's very important that there is a good legal due diligence conducted. Okay. So if it's a bank, for instance, while you assume the properties of the bank, the buildings, the asset, the computers, and all that, you must also record that you have to settle the investor, the depositors, the creditors, and all that, and all that. All right. So that is all about corporate restructuring too. And we come to the ethical duty. Under the ethical duty, we talk about duty to disclose the true state of the company in preparation for in preparation to state the true state in the true state of preparation for the mergers of the to disclose the true state of the company in preparation for the schemes of merger. And a lawyer must not allow conflict of interest under Rule 17 and duty to act with care and skill as required under Rule 14. And it is also the duty of the solicitor to the scheme of merger to devote their energy, expertise to the cause of the newly merged company and minimize post-merger conflict. That is why I elaborated on the need for a merger agreement that will be explicit, that will cover all terms and conditions, agreement, and consensus of parties reduced into writing so that nothing is left out and nothing is left for assumption. All right. And then, in respect of management by purchase and assumption. Number one, there is the duty to disclose the true state of the company in preparation for the management buyout and purchase and assumption, and duty not to allow conflict of interest and insider trading on the part of the managers in respect of management buyout, especially under Rule 17 of the Rules of Professional Conduct for Legal Practitioners. And then it is expected that the solicitors will act with care and skills, and it is also the duty to devote times and energy and expertise to the cause of the financial institution, assuming liabilities in respect of purchase and assumption, while minimizing post-assumption conflict and undisclosed liability. That is why I said in purchase and assumption, there must be thorough due diligence in order to ensure that there are no undisclosed liabilities, because in purchase and assumption, once you assume the asset, once you take the asset and you take the asset of the company and you take the benefit, you will also assume the liabilities in respect of the company. So it's therefore very important that corporate due diligence is carried out and a good background check is done in order to ascertain the position of things. All right, so that will bring us to an end for today's class. I hope you do find this very useful as we do more research and go through the slide as well as the lecture over again. And next week, when we come your way, we'll be taking the next topic. I wish you all the very best. God bless. Good evening.